All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh, give their attention to the court. Now sitting.
Please be seated. Good morning and welcome. I understand we have a visiting group from Washburn Law. Professor Peters, would you like to come forward and introduce your group?
Please support. I am Professor Eunice Peters from Washburn University School of Law, and I'm joined today by several of our students. They're seated on both sides of the aisle. We extend our sincere appreciation to the Supreme Court, the Clerk of the Court, and to OJA for helping us coordinate this experience. We have reviewed the briefs and are grateful for the opportunity to observe today's oral arguments. Today's experience is particularly valuable as our focus this semester is on persuasive writing, which culminates in the student's final assignment, which is the appellate oral argument. Thus, I also want to thank the advocates for providing us with the opportunity to learn from them today.
Thank you. Thank you to all of you. We are very excited to have you here for this experience and hope that someday many of you will be back in this courtroom as that or judges, justices. With that, ask Mr. Shima to please read or call the 9 a.m. docket.
Thank you, Your Honor. May I please declare? The first case on the 9 a.m. docket for Thursday, January 30th, 2025 is appeal number 126442, State of Kansas versus Caleb Paul Ron Hogan, Butler County, briefs both sides.
Michelle Davis appearing on behalf of the appellant Caleb Hogan, present and ready for argument.
Darren Devaney, Butler County Attorney, here on behalf of the state of Kansas, present, ready for argument.
Second case is appeal number 124904 in the matter of the marriage of Nancy Karanja Meek and Aaron Marshall Meek, Johnson County, briefs both sides.
May it please the court, Joseph Booth appearing for Aaron Meek, present and ready for argument and reserving 3 minutes for rebuttal.
3 minutes reserved.
May it please the court. I'm Jonathan Sternberg and I represent the appellee Nancy Karanja Meek, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
All right, thank you. With that, I will call 126442, State of Kansas versus Caleb Paul Ron Hogan. As counsel take the bench or their seats, I will tell you that like the students, the court has read the briefs and studied the record and have made notes about the cases. So we may be referring to those notes on our computers or on paper as we go through the argument. Please know that as we do that, it is part of our process of helping us assess the arguments of the counsel, and we are actively listening to them as they do so. So with that, Ms. Davis, you may approach the lectern.
I'm Michelle Davis and I'm appearing on behalf of Caleb Hogan, and I'm requesting 3 minutes for rebuttal, please.
3 minutes is granted.
The state convicted Mr. Hogan of child abuse and felony murder based on events that took place in March of 2021, I believe. Mr. Hogan called the police, 3-month-old baby. It's afternoon. Child had slept most of the day. He found the child having trouble spitting up a little bit, vomiting, trouble breathing, and then the child went limp, and he called 911, and the child was taken to the hospital, did not recover. The police interviewed the parents that night, the father and the mother, and each of them denied that they had harmed the child or that the other would do so. There was also some family of the parents that had contact with the child, and then the child was with a caregiver every Thursday and Friday of every week. Other than that, the parents pretty much shared or divided caregiving responsibilities. The next day, the police called the parents back in, only talked to Caleb, and he was obviously not well, tired, distraught. He gave some statements during that interview that the police then arrested him for and claimed that he had confessed to the crimes. And they relayed that information to the pediatrician, the child abuse pediatrician that testified for the state at the hospital. So she prepared a report that said that law enforcement said that father had admitted to shaking the child, and that those kind of injuries could cause the rib fractures that had been identified at the hospital. There were some healing rib fractures on the child. And what Caleb had demonstrated was, a gentle shaking where he was holding the child in front of him. And it was that this had been done 6 weeks prior, where he was frustrated and was telling the child, go to sleep, I'm tired, kind of holding the child in front of him. And then after this event happened, where he couldn't get the child to respond, he had done the same thing, holding the child, trying to get the child to wake up. So.
Let me interrupt, because this is what's bothered me when I was looking at this last week. Is your contention that the prosecution misrepresented to the jury what the video showed? Your argument, you seem to be talking about, well, it wasn't the shaking that he demonstrated wasn't much.
Right,
Wasn't
because
very
the video is
dramatic.
there. We could observe it, right? And that was, well, I watched the video, so and
Right,
then
but is it your
also,
contention that the state misrepresented what was on the video?
I'm gonna give you a long answer if that's okay. Basically, this started with Captain, there's a captain with the police department who basically said, he confessed, he admitted to doing this. And so it's, when you say the prosecution.
Well, I thought I said the state.
Okay, if you say the
Maybe
state.
the second time I said the state. I just,
Yes, and law enforcement, this started with law enforcement, and they decided he had done it. In fact, you could tell when they interviewed the mom that this captain believed that the dad had done it, because he kept trying to get the mom to say the dad had done it and didn't really confront her about whether she had done it. I mean, that's my opinion, but I watched the videos. So
I'm trying to figure out what to do with this, because in the end, the video is played to the jury and they get to see it, and they convicted. I don't know how I guess I'm trying to figure out what's the legal support for us to look at the video and say, oh, it's not as bad as the state represent. See what I'm asking?
yeah, but that's not the issue here.
Okay, that's what I'm
Okay,
getting
so
at.
this case goes to a preliminary hearing in December, and that preliminary hearing. So the law enforcement comes out of the interview and they say he confessed, right? They put that in their affidavit that he had admitted to shaking the child, but they didn't explain what type of shaking he described, right? But at the preliminary hearing, Captain Ralph testifies. This was a gentle shaking. Those were his words. So Captain Ralph at the preliminary says he admitted twice to being a gentle shaking. But then Weeks, the child abuse pediatrician, also testifies at the preliminary hearing. She says this was a violent, forceful shaking to cause these injuries. So right there in front of the prosecution and the judge is the contrast. Then the autopsy, the state's autopsy expert says this was a blunt force injury. This was not even a shaking. Shaking could have been involved, but this child was struck on an object, or an object was struck on the child. So the evidence is there. Then the motion hearing comes up 4 weeks later, or 4 months later, 3 to 4 months later, where the defense is trying to prevent, what they're trying to prevent, is not the videotape. They're trying to prevent the evidence of prior injuries to the child from being admitted, because it's so prejudicial. Because the state had no proof that Caleb had caused these injuries. And so simply putting in older injuries to this child without unknown perpetrator had no probative value of a material fact in dispute, and was highly prejudicial. The judge at that hearing says the state's going to present evidence showing a causation between the defendant and the injuries. This is a proffer hearing. It's not an evidentiary hearing. The prosecutor doesn't get up and say, that's wrong, judge. Actually, we don't have that evidence, so we can't do that. You know, you heard the preliminary hearing 4 months ago, right?
Was there circumstantial evidence, though, to support that sort of theory in the fact that there was sort of this timeline established where for the prior injuries, some of the interview from the defendant where there was an acknowledgement of prior, albeit gentle, shaking, and therefore, it's sort of a why isn't this just a credibility issue? I guess two questions. Why wasn't that enough for the jury, if it so chose, to make that inference that as to the identity of the who caused the prior injuries? And second, was it also based on that same evidence simply a credibility issue, whether the jury was going to believe Mr. Hogan or not, that made that evidence potentially relevant?
This, at the start of this second video, he's going in there going, you know, you're telling me I did this. I must have done this. I can't think how this could have taken place. Maybe this gentle shaking I did it. He didn't use the word gentle, but he's trying to explain. He's trying to work with them. Then when the captain says, no, you know, what you're describing to me couldn't cause these injuries. You must have done something more. And at the end of the video, he's going, no, I didn't do anything more. There's no credibility here. Take his statements for what they are. He denies seriously harming the child. And with the defense here, they don't have a problem. If you want to say, if he was inconsistent about the first interview, he said he didn't shake the child. In the second interview, he said he did. On the day in question, that's fine. You can bring in everything that happened around the events of what took place, right? And you know, he denies that he did this. He denies that he previously harmed the child. If you watch that interview,
can you connect the dots for me between your argument about the interview and the judge's evidentiary ruling that's actually in front of us?
That's actually,
I mean, I take it what we're talking about here is the issue of the court's denial of defense's motion to exclude evidence of prior injury, right?
right, because
So I'm asking you to, you're spending most of your time talking about the interview.
Right.
I just want you to connect the dots for me.
right, because there's no evidence. There's no, you've got healing rib fractures, perpetrator unknown, right? The defense is saying, we're not disputing this child was injured. That's not a material fact in dispute, right?
So what is
So-
the legal argument as to why the evidence should be excluded?
Because 6455.
Okay.
Because they're using this evidence. This wasn't just the evidence that came in. It was the detective saying, or it was Captain Ralph saying, you know, he did it.
Yeah,
He did it. It was the judge's limiting instruction saying he did it, right? So it's not just evidence of the prior injuries. It's they're pointing the finger at Caleb saying he did this, right? That's 6455 evidence.
Right. You're saying it was brought in for propensity, not for the purported reason that the court gave.
Right, because those things weren't in dispute. The defense wasn't disputing the child was injured, right? Let's see, the judge's reasons were that he didn't say, I dropped the child and that's how the child was injured, right? He's not claiming accident. He's saying, I didn't do this, right? So his state of mind and whether it was an accident, the reasons given are just not in dispute.
I thought the judge's ruling was that it went to the credibility about whether or not the shakings were gentle or not, you know, as he demonstrated, and also as to the credibility that the last shaking occurred after the baby had been non-responsive and as opposed to having occurred before. So why is that not
So what
go to
you-
the credibility of
Right.
those?
What you're
that timeline?
What you're
basically?
calling credibility is really just saying, is he minimizing? It's just Captain Ralph's theory. I mean, all this is just Captain Ralph's theory just getting pushed down the road.
But
He's
why doesn't the
minimizing.
jury-
The theory is he's minimizing, right? He's saying he gently shook the child, but he's minimizing. And so when the judge is calling credibility, is really saying, are you going to believe the state that's saying he's minimizing or not? And so it's really propensity evidence because it's saying he's not minimizing because look at the damage that was previously done to this child.
Well, we have case law that says with propensity evidence under 6455, even though credibility is not listed in that statute, credibility can be a factor that allows prior acts to come in.
Yes.
So why, that's why I'm trying to
Okay,
get to,
I'm gonna give.
why not here?
2 reasons here, right? This is evidence he committed a crime, right? That's not evidence, the state had no evidence that he committed the prior injuries.
he,
All we have is evidence of a gentle shaking and then denying that he caused the prior injuries. No, I didn't do anything that would have caused these significant injuries. At the time, he doesn't even know the extent of the injuries, right? This is the night, the day after it happened. He doesn't have all the autopsy photos and all that. He's just saying, you're telling me my child's hurt badly and I didn't do this, right?
didn't the, I'm sorry, I can't recall which doctor, either the pathologist or the, Dr. Wells, say that holding the baby as described could result in fractured ribs?
As what law enforcement had relayed. Law enforcement says dad admits to shaking the child and holding the child and shaking the child, right? But they didn't say the gentle shaking part, that this was very just kind of waving the child in front of me, right? So she's making her conclusion based on what Captain Ralph is saying and telling, right? As did, it just kind of filtered through the case. He did not admit, and at trial, all the experts acknowledged that. With the type of shaking that he described would not have caused injuries to this child. She acknowledged that, right? She never saw the video. She didn't know. She was just going off of what she was told. And they're proclaiming a confession here. So she's assuming this is the violent, forceful type of shaking that she said would be necessary at the preliminary hearing. And then the other part about why it's not admissible, you said this in Prine. The state can't open the door to 6455 evidence. The state can't, the defense has to open the door by its defense at trial or something that's said at trial. The state can't, the state admitted the video, the prior statements. The state can't do that and then say, we're putting in his statements. And so now his credibility is an issue. So we get to bring in 6455 evidence. I mean, if you did that in every case where the state was putting on the defense prior statements, they could always say credibility is an issue. Right? We've got something different at trial than what he said before, so we can bring in 6455 evidence. No, the defense has to open the door to 6455
I'm wondering
evidence.
if, as I described earlier, I was having trouble connecting the dots between the interview and the actual evidence. And I'm wondering if the disconnect is this even 6455 evidence? I mean, is it a prior bad act? It's just evidence of a prior injury.
Right, but the problem is you've got the captain telling everybody he's confessed.
Well, but that evidence gets tested in the adversarial process of the trial. And as you pointed out, the defense apparently was able to pretty firmly refute that.
No, I don't think so, because he was convicted.
Well, I don't think you can reason backwards from that. The jury obviously didn't believe your client.
Well,
But my question.
Or
really-
they were prejudiced by all of the evidence of prior injuries to the baby. I mean,
Well, but the question is whether or not that evidence is admissible, right?
You can't have it both ways. You can't say this is not evidence of a prior crime when the state is saying it is evidence of a prior crime and telling the jury it's evidence of a prior crime through their witnesses and through a jury instruction. When everybody's telling the jury it's that, you can't say it's not that. If it's not that, then you admit the evidence of the injuries. You give a limiting instruction saying evidence of injuries to this child has been admitted. There's no evidence that the defendant caused these injuries. But then the jury's saying, well, why are you admitting the evidence then? How is it relevant? And you know what? If I'm on the jury and I've got a judge telling me to consider this evidence for accident, lack of mistake, credibility, I'm thinking, this guy did those prior injuries because why else would the judge be telling us to consider it? And you know what? They're right. There's supposed to be a court finding. Before you admit that evidence, a judge has to find that it's relevant. In order to be relevant, he had to have committed those injuries.
He tells them you can't consider the older injuries to support the conviction of either child abuse or felony murder charge, but you may consider. So he distinguishes that. Is it as strong as what you're suggesting in terms of a directive to the jury?
You have the limiting instruction, but you may consider it for That's a mistake. That's what you're referring to? Right. So what's he telling the jury to consider it for then?
So what's the,
He's telling him to consider it for whether Caleb acted knowingly. And if he was credible. I mean, so basically what the judge is saying is, there's been some, what I'm thinking is there's been some finding here that where the judge found that Caleb had committed the prior injuries, because why else would the judge be telling us to consider it? I mean, if we're to consider prior injuries in determining whether Caleb acted knowingly, he must have done the prior injuries, right? I mean,
my point is, he's not really telling them to consider it. He's telling them they may consider it. Is there a
Right.
difference there?
but why would you be telling us that unless you're saying it's probative? I mean, it's probative. I mean, what else? It's probative of, to say whether he's done knowingly, that's not his defense. I mean, he's not saying I did this, but it was, an accident. He's saying, I didn't do this, right? So this limiting instruction is just worthless because the jury either decides he did it or he didn't. There's no innocence here. There's no innocence defense. I think I'm out of time. I'll save my remaining comments for rebuttal.
All right,
Thank
thank
you.
you, Ms. Davis.
Morning, may it please the court. Darren Devaney on behalf of the state of Kansas. There's, I guess, the legal issues of 455 or the admissibility of this evidence, and then there were the facts of the case. I was anticipating, I guess, the analysis of one thing that's already been touched on, which was this evidence actually 6455? Because it's kind of, in a way, it's a little bit of a split order that we had in the pretrial motion in limine. And I want to make sure that this timeframe is very clear with the court. There was a preliminary hearing that occurred back in December of 21. Some months later, the trial counsel for defense filed a motion in limine with the court. Putting this issue at hand, the state didn't file a 6455 motion. The state hadn't considered whether or not a 6455 needed to be filed at the time. It was trial counsel for defense that initiated this and kind of opened the, I'll say, not necessarily opened the door, but opened the argument up in front of the trial court.
What was your theory on the prior crimes if it wasn't 6455? I think I follow you, but what was it like?
Well,
Race gesti? What are we talking?
I was looking, my attention was focused on the autopsy itself. And let's get away from the defendant's statements for just a moment if we could. But the autopsy, we had an autopsy performed. It showed healing rib fractures on an infant child. Those healing fractures and blood on the brain, some of these types of things from the pathologist occurred 4 to 6 weeks prior to. To ask a trial judge to excise portions of a autopsy because it showed prior injury, and we don't want to taint the field with any prior injuries. To me, that's a very untenable situation for any district court judge to go through and piecemeal what is scientifically valid for the purposes of proving this particular crime, as opposed to other scientific aspects that might be part of the autopsy that may not comport or may make somebody look bad, or would even be constituted or argued by a lawyer to be a prior crime or bad act. That is to say, that autopsy is its own document, which is objective in nature. It's presented to be objective. And that's going to include every injury or every disease, height, weight, everything. And so that was part of the motion in limine, but filed by the trial court defense, which was to excise those portions, excise the prior injuries to the child, because we couldn't bring that in. And he puts that in line with, in parity with, the defendant's statements, which he says, there was soft shaking. There was even mention in the interview that occurred in Newton with Captain Ralph that I believe the defendant said he had the child in a car seat, might have bumped the car seat and caused some kind of prior injury. And so there was supplemental information with regard to what prior injuries might have occurred but they simply weren't credible. And it appears to me that at the end of that motion in limine, and if you go through and read that, the transcript of the motion in limine, there are three items really up for grabs. One was the autopsy, one was the statements of the defendant, and the third was the admissibility of the polygraph testimony. The state very clearly said, we're not going to admit anything. We're not going to mention polygraph. We don't take issue with that. But the other issues with regard to the autopsy and the statements of the defendant seem to go towards credibility. The trial court is the one who frames the response to the defense. And when he does so, he says, I see this as 455 evidence. I see this as absence of mistake or accident. This is 6455. He says, however, that is balanced against the other use of this information, and that is one of credibility. And when you look at the statements that the defendant made with regard to the contact that he had with the child, and even categorizing them as a confession, I think that's, by the way, I think that's still accurate. And it was a confession. It was a confession of the fact that he isolated the timeline that he was with that child. It was a confession to the fact that he had hands on this child. And it was a confession of the fact that he at least shook that child, and he demonstrated such on video.
Let
Now-
me ask you a question. So do you agree with the trial court judge and also, Justice Stegall? Is this evidence of a prior bad act or a prior crime?
In all honesty, when I reviewed this transcript, and I was not the trial attorney on this case, I reviewed this transcript. That the first boring question I had in my mind was, is this 6455? Is this a prior crime or bad act? Now, certainly we don't use the title of a statute to define the content of a statute necessarily. When I look at this, I had trouble finding this to be a prior crime or bad act, kind of in the idea of propensity of violence.
Okay, let me ask you this. Could the dad have been charged for the prior shaking as child abuse because of the injuries to the ribs?
Could he have been charged? I would say, I'd probably give you the same answer I'd give with regard to any crime, Justice. And that is, if there's probable cause to believe he's committed all of the elements of that offense, and we have sufficient evidence to believe that he was actually the person that did that.
Mhm.
But I think it is far more specious for me to say that we had enough evidence to charge him with that second event. I don't
No,
believe.
I want to focus on whether the trial court judge said it's 6455.
Right.
It's prior bad act or a prior crime.
Sure.
All I want to know is whether you think that's true, that the prior shaking softly with, in combination with the healing rib injuries, whether that would be a prior crime or prior bad act. In other words, was the district court correct in saying this?
I would
is
love to give you a black and white response
So
to
I would
this.
love to hear a black and white answer.
And I can't, and I'm sorry, I can't. Because I don't know the nature, I don't know the circumstances, and they're not fully developed, and nor do we get more of the story from Mr. Hogan of exactly what went down with the prior injuries.
Well, can we
What I
say
have is-
Isn't that the
committed a crime?
point?
I'm sorry?
Can we say someone committed a crime? And then that gets to this defense argument that the state inferred it was Mr. Hogan, but yet there's no evidence that it was Mr. Hogan.
I think the prior injuries, and I have to keep my mind broad every time I hear about child victim injuries, I would need to know more before I would say, yes, that's clearly criminal conduct.
Okay, so let's say that it is. Let's say it's a prior crime or bad act. Let's
Okay.
go with what the district court judge concluded. It doesn't seem as if anybody objected to his characterization that way. So then what happens is it can't come in unless but it can be used. It can't be used for propensity, but it can be used for motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or accident. And if it is one of those, then the court has an obligation to determine whether the probative value outweighs its prejudicial effect. And so let's say that we find it's probative, okay? Did the district court err in failing to say anything about the prejudicial effect? Well, actually, when you look at probative value, let's look at probative value. Here's what we're supposed to consider, and this is under the Clarehout decision from 2019 that we issued. So when he's just talking about probative, how clearly was the act proved? The prior bad act, okay? How probative is that evidence on what is being charged in this case? How seriously disputed the material fact is, and whether the government can obtain any less prejudicial effect, okay? You could say that the judge found probative value, but I don't see that any of these things were considered. But then you have to go to prejudicial effect, the likelihood that the evidence will contribute to an improperly based jury verdict, distract the jury from the central issues of the trial for this particular act, and how time consuming it would be to prove the prior act. But of course, they never proved the prior act, so it wasn't time consuming. But I just don't understand, did the district court err in doing all this? It just seems like there was absolutely no weighing of probative value versus prejudicial effect.
And if I'm to understand correctly, it's the statements that the defendant made that are inherently so prejudicial, or at least that's how you're couching that question or the point that you're making?
No, bringing in the prior bad act or prior crime of the previous shaking 6 weeks earlier, that they are asking the jury to infer that he committed that crime.
Sure.
Because of the old.
If I may just add some context here, that you may want to add into this, your answer to Justice Standridge. All I could find in the limine transcript, motion limine ruling, was the judge making this passing statement. And the court finds that the probative value of the 6-week-old injury evidence outweighs its prejudicial effect. And then he goes on to say, I will need to give a limiting instruction. If there's something more in the record that I missed, you might point that out to us as well as you talk to answer Justice Standridge's question.
Okay, trying to address both of you equally, but I'll address this first, if I may, which is I'm not aware of anything else in the transcript where there's an elaboration of the probative prejudicial balance with regard to this.
So those factors that Justice Standridge mentioned.
Right. So no, I'm not aware of any well-developed, I guess, like I said, transcript or the fact that colloquy might have occurred even beyond the transcripts. But I'm still struck between the idea of we have probative prejudicial, which is we weigh that for every bit of evidence that we have and use for trial to distract the jury. And that's and that was one of the factors that was mentioned as well. But this wasn't, the case was not reliant upon the prior injury. This evidence was admitted, but again, how do you pair out?
I'm just talking about when, the judge made a decision here. The judge's decision is reviewed for abuse of discretion.
Sure.
One of the issues, one abuse of discretion is an error of law. Why isn't this an error of law that the judge didn't even consider the prejudicial effect, let alone, the elements of the probative value? But you could say, well, but he talked about the probative value enough that, he doesn't have to state, or she, I don't remember who the judge was, but state everything on here. But there's just no contemplation of which, it seems like that the prejudicial effect might be a pretty big issue.
I think undoubtedly every time we look at 6455 evidence, we always worry about the prejudicial effect.
Well, this
is why
judge really,
455 is a statute.
Yeah.
This is why we have it codified.
did the district court judge err? Did the district court judge abuse its discretion?
I think those factors need to be weighed. I think the fact that the transcript does not necessarily contain that balance of going through the probative versus prejudicial at length with regard to the fact.
At length?
There was no length. I mean, he just said, but I mean, absolutely. I can't change the transcript, but.
Summary conclusion.
But I think that was also, it was a summary conclusion, but the debate, the back and forth, I think if you look at the entirety of the transcript of that hearing, was considerably longer. The content of what it is that's being addressed here, the trial court gauged.
It all went to probative value. The whole transcript.
Sure, but the court's rationale was also focused upon the admissibility of this information under credibility issues, 6421, 422, those types of matters.
Well, let's just, what if, just for a second, pretend that the court infers that that finding is made. Why isn't this prejudicial? More, what is the case for it not being prejudicial? Because I think it strikes me that the explanations for its admission, credibility, meaning that he didn't gently shake, he actually abused the child, and not a mistake, meaning that he did those prior things. It seems an argument might be made that propensity sort of permeates those rationales. But I want to hear your argument as to why that may not be the case. And
the first part of what you proposed was, isn't this actually prejudicial? And I would say absolutely. Everything the state presents
unduly
is prejudicial. So it's really the balancing test of probative versus prejudicial amongst, it also has to be relevant and et cetera. We know these things, but
I guess the question is, why doesn't the prejudice outweigh?
It's really the risk of undue prejudice. I mean, sure, what you're saying is
sure,
a lot of it's prejudicial, but here the weighing is, does the probative value outweigh the risk of unfair or undue prejudice?
My answer to you is it was accurate in this case to admit this evidence. And I go back to what I opened with, which was the statements of the prior injuries. The jury needs some explanation of the fact that we're looking at an autopsy of a dead infant that has prior injuries. Is nobody to address that?
And
is that not to be explained to the jury? And so in doing so, we have to say, and the state played their cards. They said, this happened to this child. He's not charged with these crimes. We don't know whether Caleb Hogan committed those injuries to the child 6 weeks before the death, or somebody else.
Right. And that's what I would like for you to focus on right now. If a judge's ruling can be right for the wrong reason. So if for argument purposes, we assume 455 doesn't apply because you can't prove that the defendant did a prior crime or civil wrong that relates to that prior injury. So set aside 6455. You have an autopsy that has evidence of a prior injury and a current injury. That has to be sorted out somehow. What was caused recently? What was caused long ago? Is there an interrelated effect possibly? What is your strongest argument that the evidence of the old injury to the ribs, to the brain, was relevant and probative to the charges in this case?
Best argument I have is that.
I'm sorry, material and probative. Those are both things that are subparts of relevance, and all relevance is presumed to come in. So what's your best argument? I'm sorry, I misspoke. That evidence of the old injury was both probative and material.
Probative as to the defendant's credibility regarding the statements he made. He told law enforcement officers that interview with Captain Ralph that the prior injuries might be connected to He mentioned something about, he was in a car seat, might have bumped the car seat. And he had some kind of contact that may be related to the prior injuries. It was a minimization on behalf of the defendant. Just like it was a minimization when he later described the shaking that he did with that child. And he minimized it. Now, in both circumstances, this is a question then of the credibility of the defendant and how that's weighed.
So evidence is probative if it has any tendency to prove a material fact where, you know, a material fact is a disputed material fact.
Sure.
So was his credibility, what did he lie about?
I believe that he completely minimized the fact. He never said, I killed this child by this means and thoroughly went through it in great detail. He minimized it. His credibility, the defendant's credibility in those statements have to be tested, have to be aired out in front of the jury. And it's the jury that has to decide whether or not he is credible. Those statements or the statements that he made were credible. That's essential in this case as well as most others, actually. You know, was the defendant, any statements that the defendant made that are admissible have to be tested for credibility.
So doesn't that swallow the whole rule then? Because
sorry,
credibility, you know, you can't use it for propensity evidence.
Sure.
But even though it's not listed in the statute, as Chief Justice Lukert mentioned, but if you're saying that everybody's credibility is always at issue, doesn't that swallow the rule of, well, propensity evidence can always come in?
No, I think that if it's going through the route of 6455 and is one of those 8 identified factors.
Which credibility is not one of.
Absolutely. But that's just it. If it's one of these factors, which again, the trial judge determined, he was the one that advanced the theory that this was 6455 in that motion in limine hearing. The state was looking at this going, this is mere credibility issue. We're going to admit the autopsy. We're going to have some explanation as to the prior injuries. And it was in response to the defense initiating this.
So bad to not have the prior injuries in.
I'm sorry, why would it not be so bad?
Right. I mean, couldn't you prove the case without the prior injuries?
You could, but that would also require, like I said, a trial court to then start excising every autopsy to determine what is scientifically relevant to the death versus not. Can we talk about this? Can we not talk about that?
Or could there have been a limiting instruction that just said you can't weigh those prior injuries against Mr. Hogan?
Well,
Because there's no evidence.
And that's where I think, you know, if nothing else, the saving grace and I don't mean to be ever be flippant about our judicial system here. I have yet to be part of a perfect trial, no matter what it is. And I think that as the course of this case went through, Judge Ricky heard this evidence on this motion in limine. He anticipated, hey, you know, it's seemingly 6455 to him. And if we are going to do 6455, the law is going to require that limiting instruction. And he proposed at the end of that motion in limine hearing, I'm going to go ahead and prove that, make sure it's in the journal entry of today's hearing, that we will have a limiting instruction. And then certainly when it came to trial, there was a limiting instruction.
And it was not objected to.
Correct.
We're in clear error land. And one question I have about as we get to that area, do you consider the objection that was made so that as I understand, the procedural history of this was that there was the motion in limine ruled on, then at trial, when the forensic pathologist was testifying, defense renewed their objection to the admission of the autopsy report. The judge ruled that the autopsy report and related testimony would be admitted, and defense counsel made a continuing objection. Do you understand that continuing objection to be to any evidence of the prior injury throughout the trial, not just to that witness? Or do we, when we get to harmlessness, consider the fact that it came in multiple times in the trial? And I mean, just what was the effect of the continuing objection?
I think I would be in the treacherous area of divining what those words meant from the transcript. I would say that I would just have to rely on the transcript of the trial. I think that, and that's all that was said, I believe, which is, I noted the continuing objection.
And I noticed the state didn't, or hasn't argued preservation of the,
Yeah,
you know, so I take it, you take it, the continuing objection does apply to the trial.
I would anticipate it as such, and I think with regard to the reservation, to me, the context of that, when I went through those transcripts, were this is what this is referring to, and we'll refer to someday when we're before a higher court.
Okay. Any other questions?
Just hopefully this is real quick, but it refers back to an earlier question Justice Standridge asked, which is about charging for the prior injuries. Presume the state's theory of this case was that the defendant had abused the child 6 weeks earlier and then the incident that caused the death, right?
I'll stop you right there. No. What the state's theory was, he committed acts, I believe, on or about March 23rd, 2021, that led, the acute injuries on that date led to the child's death.
Had you charged the defendant with the abuse that occurred 6 weeks earlier, all this evidence would have come in, right? There wouldn't have been any question about 64.
Absolutely.
So my question is, isn't one of the purposes of 6455 to essentially tell the state, look, you can bring this evidence in, but what we don't want you to do is allow a jury to consider essentially that it lowers your burden of proof. Like if you had charged him with it, then you have a high burden of proof. You could have got this evidence in by charging it. The concern in 6455, the policy concern, I think, is, look, we don't want a jury to consider unproven allegations as propensity evidence. And that's how I understand the defendant's primary argument. So I just wanted you to respond to that based on the purpose, the policy purpose of 6455.
Well, what you are discussing is the initial charging phase and how the initiation of a prosecution for the purpose of looking at what all evidence might be admissible in trial and ultimately potentially lead to a conviction. I don't agree with the premise that 455 is somehow directive of going, hey, prosecutors, make sure you charge everything at the get-go of this case. Add more crimes so that way it comes in and then you don't have to go through this gateway. I think 6455, first of all, was not anticipated nor filed, that we did not initiate this as a 6455 admissibility issue. This was something imposed upon us by the trial court. Defense opened the door to it. When you talk about the state's theory or how we should progress or how we should even charge this, not on our radar until that hearing that day, until the hearing on the motion in limine. And that's the first time it was discussed as 6455 because that was postulated as being exclusion or necessary to be excluded by defense counsel. So the court says this is 6455 and he couches it under the two rationales, one of credibility, the other under 6455 absence of mistake.
I understand all that. I guess my point is just I'm questioning whether or not, and I think you said you don't agree with me, but 6455's purpose is to eliminate ghost charges. You can't have a ghost charge that you don't actually have a burden to prove.
No, I see.
If you disagree with that,
honestly, I've never contemplated it in that fashion. I really haven't. And is that a directive of sorts? And I guess if so, it's either a subtle one or I'm a dullard and never caught on to that. But I believe this is about. I don't believe that our existing law under 455 is using this evidentiary rule as a directive, as a signal or a beacon to prosecutors of make sure you charge everything for admissibility. I think that's some five-dimensional chess going on if it is. And so again, maybe I'm just don't have the wisdom to have looked into it under that light, but I respectfully disagree that that's the assessment.
But it was always your intention to talk about the prior injuries with the jury. right?
It was always the state's intention to admit the autopsy in full.
Which would include the prior injuries, which would have, it's not like you were gonna put this in and then not talk about, I mean, you just can't just let it lay there, right?
That was the quandary we were in, which is.
Well, I don't care about the conduit. Your intention was to put evidence of prior injury in front of the jury, right? That's what was going
Yes.
to happen with what you were going to do.
Yes, the autopsy. Yes.
Well, isn't it possible that that prior injury somehow is relevant to the seriousness of the current injury? That perhaps he was right, you know, that, and the defendant was being truthful. I only shook him gently. And here we have evidence that something else happened to him before, and that may have contributed to what very little I did, or which would minimize his culpability.
It would, but the coroner and pathologist, they both testified and said that there were prior injuries, but it didn't capitalize on that. And there was some severability, I guess, with regard to those healing injuries. They said that there was evidence of old brain bleed, and healing rib fractures. I believe at the time the child died, the child had 16 broken ribs, but noticed that 6 of those were healing.
And it could have benefited the defendant to say, look at all these other things that happened to this poor child, and we don't know who had access to him or who did those things during that time. But what I did not cause his death.
And I think that's what he did proffer. And I think that's what was put forward at trial. And he did advance that theory.
Is that relevance to the total evidence without even considering 455?
As to the credibility of his statement,
As to the overall cause and effect of what the doctors found when the child was on the table, deceased.
relevant to explain the evidence to the jury so they could make a reasonable decision. Yes. It is relevant to the res gestae, the body of this case. Say you have a child who's 3 months old, has 6-week-old injuries that are healing, has present acute injuries that led to the child's death. You have the only people that say that they had any type of physical contact that would have led to injury is the defendant, Caleb Hogan. He's given statements about the past injuries, but the present injuries seem to be minimized. As a result, his credibility becomes extremely valuable when you look at that in total with the autopsy and the prior injuries and the knowledge that all of that needs to come out. Shedding light on what is the story was, shedding light on what the defendant had to say, and trying to explain to the jury even-handedly, and with the inclusion of a limiting instruction with regard to how to use that evidence, was the best protective that we had under the facts of this case.
So
Is
you
that
just,
relevant even if you assume he did not do the prior injuries?
I think defense could advance that theory that he did not do the prior injuries, but
That is the
I don't know that
relevance.
any of us know that.
Is the evidence of the prior injury relevant if you assume he did not do those prior injuries? Because 6455 only applies if he did.
Mhm.
So if you assume he didn't, what's your best argument that the prior injuries are still relevant in being material and probative?
If I assumed he didn't do it, then I think that the evidence would still have to come in to explain his statements and the fact that there at least were some injuries and that he is at least among those that were suspected of committing that type of injury. But I don't know. I don't, and I don't. I have no idea who committed the injuries or how those injuries occurred from 6 weeks before. Be that the mother, be that the defendant, grandparents, anybody that had contact with that child. So I can't tell you today. I know Caleb. I know that he committed the injuries from 6 weeks ago, and that's precisely why he's not charged with the crime of child abuse.
Do you need it to tell a full and complete story of the existence of the physicality of that child at the time of his death?
I don't even know if I heard exactly what your question was. Could you
Well,
repeat that?
do you need it to fully explain how the child was at the time of his death? Because you have to connect what the defendant did to the deceased's condition. So do you need it to fully explain the condition of the child at the time of his death? Or not?
I believe that the explanation is merited. This child was 3 months old when he died. That's a very short period of time, sustaining 6 broken ribs and then later 16 broken ribs in 3 months. In 12 weeks, this child was horrifically abused, and then you've got the the other injuries as well. I think in total, yes, I think that's going to be an explanation that a jury at least needs to weigh and look into. The jury needs to go, oh, what's going on with this child? Was this child, and I think they would ask the question, but it was explained at trial as well as, did the injuries that occurred 6 weeks before contribute to or accelerate any of the problems that occurred on March 23rd? And it seemed to me when I read through that transcripts seemed to indicate that they said, no, they weren't life-threatening 6 weeks ago, but certainly there's still evidence that they're healing injuries. But you're talking about a very short period of time that this child was between birth and death. We're talking about a very narrow window of time here. And to be able to explain that to a jury and say, this is what this child's life looked like in those 3 months, I think is absolutely appropriate. And one of the cautions, I guess, that seemed evident with this from the very moment that the trial judge made the order was, but we are going to give a limiting instruction. We're going to make sure that the jury understands that you can't use this prior injury, that needs to be separated out, and the charges for which the defendant is standing trial is for the acute injuries here. But
is there any evidence that an already injured child is easier to injure?
Well, I think that is possible, but not
aside from what you think. Is there anything in the transcript, respectfully, is there anything in the transcript to indicate that?
No, I don't believe so.
Are there other questions? Okay, thank you, sir.
Okay, thank you very much.
Ms. Davis?
Just briefly, I think what your questions today show is what my brief tried to point out to you is that the state had the burden to establish the admissibility. And at that motion hearing, the prosecutor was didn't present. And the judge had an obligation as a gatekeeper to hold the state to that burden and to make the state proffer the evidence. And the judge didn't do that.
On that
The
point.
state didn't proffer anything, so the judge just made his own assumptions.
So on that point, am I correct in looking at the record that there was never any discussion of the res gestae exception to 6455 evidence?
No, there wasn't. And I thought Gumby had done away with res gestae, that everything has to come in through 6455.
Okay.
So
Yeah, we
basically-
declared race gestae dead in Gumby. I
Yeah.
think that was almost the words, but
But is it dead?
we have revived it.
Nope.
I mean, it's been revived. And that's kind of my question. I was waiting for you to get up here. Why isn't it as a part of our extension after Gumby, this come in under race gestae? What's your answer to that?
because the state didn't establish that.
Well, that was
And-
gonna be my question.
I
Is
mean,
it-
we
is-
can't-
Are we unable to consider it because it wasn't considered below? And just for reference, in our Sieg decision from 2022,
Right.
we clearly say that, you know, acts committed before, during, or after the happening of the principal occurrence, which are so closely connected,
Uh-huh.
form a part of the occurrence, are not subject to 60.
You know, since we're supposed to object at trial in order to raise issues before this court, you think maybe the state could raise
Yeah, well, that was my question.
issues before the trial?
I presume your answer is yes, we are prohibited from considering race justice.
They needed to come forward and say, this is why we want to. And you know what? There was an omission here because when the judge said, you know, I'm going to admit these evidence because that states, I'm going to admit this evidence. It wasn't just the autopsy report. In the interviews with the detective, he was repeatedly telling the parents, they're seeing prior injuries on this child. The prior injuries were all over everything, right? They were in all the interviews because the hospital identified him that night. Now I lost my train of thought. At the hearing, the motions hearing, when the judge says that, the state's going to present evidence of a causal link between the defendant and the prior injuries. The prosecutor needed to jump up and say, no, we don't have that evidence, Judge. The state wanted this prior injury evidence to come in to show propensity. They were just trying to sneak it on in there, right? The prosecutor never stood up and said, we don't have that evidence, but we want to admit it to give the jury a full picture of this child's condition. And you know what? We have an expert that can say that the prior injuries contributed to the death. The prosecutor didn't say that because they didn't have an expert, because they didn't proffer that evidence. The defense expert said that the prior injuries did not contribute to the death. So really, this is a failure of the state to prove that this evidence is admissible, a failure of the judge to hold the state to its burden to do that, the failure of the judge to act as a gatekeeper. And I did note on the, you don't even need to admit the autopsy report. He's not contesting that the child died and these were the injuries. I mean, the only reason to get the autopsy report in is to argue propensity. He's not contesting this. And then it was a car seat. I mean, it's not a car seat, it's a carrier. The mom bore all day, had the baby in a carrier when the bruise developed. That was what they were talking about. And then just to really clearly, I know I'm out of time, but on the prejudice, it's that the likelihood the evidence will contribute to an improperly based verdict. That's the unduly prejudice. Improperly based. It's an emotion. Emotion and reason are two different horses going in different directions. I think that's Plato. You can't reason an emotion. That's the problem with this evidence. Anyway, I'm out of time.
Any other questions? Okay, thank you.
Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement. What I mean by that is that later today, the court will begin discussions about this case and our potential resolution or our eventual resolution of the case. One justice will be assigned to write a draft decision of that case. There may be a unanimous agreement. There may be some people who disagree. So there may end up being multiple decisions being written. Those will be circulated. All 7 of us will review those as we do that process, making changes as it goes. Eventually the decision will be filed. That happens usually on a Friday morning. And when it does, we do issue a public statement announcing that decisions in the cases of that day and what they are with a brief summary. But the entire decision is posted on our website at kscourts.gov. We try to explain our thought process so that you can see it. You may not agree with it, but at least you have the opportunity to review it and understand the process that the court and the analysis the court went through. So with that explanation, again, thank you, counsel, for your arguments today. I will now call case number 124904 in the marriage of Mary Karanja Meek and Aaron Marshall Meek. Sorry for apologies if I misspoke on the name pronunciation.
Joseph Booth appearing for the appellant, ready and for argument.
You may begin your argument if you would like, Mr. But if you need a minute to gather, take that as well, so.
In consideration of the Court of Appeals review of what was effectively a review of the Boutro case as much as it was of this matter. A lot of attention went to the nomenclature that was used as far as marital and non-marital property. And during oral arguments, we walked between 23-2601 and 23-2801, and that transmutation of individual property during a marriage that's held into marital property and the hodgepodge that we have in divorce actions, and how the court's discretion is broad and how it would have access to all the assets. And they took offense to the Boutro case in the sense that it talked about separate property in the middle of a divorce action when that's the one thing there can't be is at the initiation of a divorce action, you have this idea that you're going to bring everything in for consideration. But they didn't concentrate on is the 40-year-old social policy of looking at the nature of some of these assets that are part of the marital estate, even those that haven't arrived yet. Refer to them as inchoate kind of assets. And those are common across the board, and we see that. But the unique nature of a personal injury award brings in the idea that you're replacing something that was lost some time ago, but that loss is continuous after the marriage, and there has to be some way to determine. And what Boutro did was it created the rubric, the 4-part piece, purpose of the award, the time period of diminished earning potential, the nature of the underlying industry, and the terms of the award. And the trial court skipped through that analysis, and so did the Court of Appeals. They didn't look at that rubric. Nothing in that rubric takes away the court's discretion on how it's going to do what it needs to do to make an equitable award, but it defines that equity in acknowledging that Mr. Meek's case, he was a survivor of an explosion, suffered debilitating injuries that will last him his life, probably cost him some years off of his life, and continue on. The settlement that they reached had the loss of consortium plus this devastating ongoing loss.
Maybe this is too colloquial, but it isn't the question whether you put that in the big bucket during once the action's commenced, or whether it stays out of that big bucket altogether. Is that the essence of this argument? Meaning that does it go into this maritable property bucket or not?
Each of the cases, Lash, Powell,
Yeah.
and did I answer?
Yeah. Well, I just wanted to get confirmation that that's the essence of this dispute, but I guess not including it in the bucket, I don't understand how that is consistent with 23-2801. I understand the case law, but I guess how does that case law survive scrutiny under that statute?
Because it goes in the bucket. It's how it comes back out the other end. The analytics, you can't make the analytics if you didn't have the bucket.
Right.
And so 23-2801 is a jurisdictional statement. And the way I would explain it is in some other states, the court doesn't have jurisdiction over certain species of property, whatever that may be. And the court just really can't do anything with it. The arguments are whether the court can touch it or not, and then what the court's going to decide. And there may be arguments about what effect that may have. We do it all the time in premarital or gift situations, inheritance, the court knows that could do whatever it wants to with that premarital asset. Let's say a short time marriage in a house that came into the marriage and was paid for when it came in, you know, that kind of hypothetical. It's in the bucket, but in Kansas family law, we pretty well know that it's going to stay in the original homeowner's control, and all that's going to be really messed with is whether or not there's been some increase in the value during the marriage.
Because that's equitable, right?
Right, right. And this is a discussion on a rubric of how to do equity.
What bothered,
Go ahead.
what bothered me in this case is that it seemed that the district court felt very confined and constrained by the settlement that had happened earlier with the insurance company and said, well, that was just done earlier and I'm, you know, so we're going to be stuck with that because of res judicata. What's wrong with that?
It's completely wrongheaded. We constantly bring in, by agreements of one form or another, assets into a marriage. The couple takes assets from wherever and buys a home in the middle of their marriage, and they put it in joint tenancy with right of survivorship. That's a contract, and that's binds it. And they have a species of ownership that they've decided in that contract, and the court's not bound by any of that. This couple turned around and took a large global settlement that had no demarcation on what was consortium and what was pain and suffering, et cetera, and made an agreement to have two separate annuities that would pay out over two separate lifespans. There's a lot of good reasons for doing that, including the fact that if you put all the eggs in the basket of this injured man's lifespan, you've sharply reduced the value of the annuities than you would if you added two separate. It's there in the bucket, as you said, and he was also criticized for not considering his share as marital, but did consider her share. Well, if you have two assets of equal value and you're asking for greater than half, that's how you do it.
Can you clarify that for me? Because I got mixed up. Okay, so the district court, did he or she or whoever it was say that both of them go into marital assets?
He considered it, I believe, he used the term separate property. That he separated them out and said, this is their separate property. We're controlled by this original contract, and I'm not going to disturb that. And in fact, chastised Mr. Meek for trying to reach into her separate property and not offering some of his. But if you have two.
And then the Court of Appeals said, what about that?
My view of it was, first they said it's all marital property. Stuck to that 2601 and 2801.
Right.
Kind of logic, but didn't look at the social policy around what was the purpose for that body of settlement.
But if we're saying didn't look at the purpose for that pot of money, don't we just look at the plain language of 2801, which incorporates 2802? I mean, why does that come into play? Because the statute's the statute. It says, even if it's an inheritance, like you said, no matter what it is, it all goes in and then it's sorted out under 2802, the equitable. So why should we even be considering what the intent was when they separate? The intent of a father who leaves his daughter $2 million as an inheritance is that my daughter's going to get that, but it still goes into the pot, right?
Mm-hmm.
So what's the difference?
It goes into the pot, the inheritance, and then I've been practicing family law for about 30 years here in Kansas. It almost always gets set aside because you looked at the original donor's intent.
But that doesn't say anything about the statute. That's just practice in family law in Kansas, but it's not written down anywhere.
Correct.
Okay. So
if you're looking at relative needs, based on, the loss, generally in a tort case, loss of consortium is much less than the loss that's incurred by someone who has a life-changing traumatic brain injury.
Mhm.
So these people decided to, when they got the money and the settlement, they decided to divide that in half. So logically, that would mean in her half included a lot of what would have been assigned to his injury. Is that fair to say?
I believe it's an inescapable conclusion.
So then if the judge felt like he was stuck with that, then he wouldn't be able to consider equitably how much, let's say each annuity is at $100,000. He can't consider what's equitable for dividing that pot based on her loss of consortium versus his loss of a traumatic brain injury. Is that kind of what happened here?
It is what happened here.
But can't the district court consider that under 2802?
Well, in this case, they effectively said, I can't, and you can't argue this, that you used res judicata as one of the reasons. You can't go back and reshuffle that deck of cards in an equitable division. But like the purchase of a house or other just mundane things that we do in contracts that upset this 2601 issue of this is my separate money and you can't have it. You turn around and throw it into joint ownership, and then you have a divorce, and then it gets broken back out into separate ownership.
Can I jump in and maybe approach the problem from a different angle? What from your perspective is wrong with the Court of Appeals decision?
There were two issues that concerned me, and the first is I believe that the social policy expressed in Boutro provides good guidance to the court without removing its discretion on how to work through a personal injury award. And that social policy, which has been around now for about 25 years and has roots back 40 years.
So you want to preserve a judicially created social policy as opposed to just allowing district courts to follow the statute?
I want both. This does follow the statute, and then
I mean, that's what I'm driving at. I don't see where the Court of Appeals did anything that prevents a district court from following what Justice Standridge just referenced, 23-802C, which lists a whole bunch of factors, which that's policy, but it's legislatively created policy. Why don't we just stick with that? And isn't that exactly what the Court of Appeals did?
The Court of Appeals hyper-focused on this issue of marital, non-marital, and basically put it back in.
Well, wasn't that because you appealed the district court's ruling that it was separate property?
True.
So you won.
Yes,
I don't understand why you're here. That's
Yes.
what I'm driving at.
It is precisely the way that it was coined when I carried the message of the decision. We won, but we need to appeal this. The second reason.
Right, so why? What is it that you hope to accomplish?
Well, the second reason has to do with the fact that then the remand is you get to decide whether or not what you decided was equitable anyway. And how does the court turn around and say, the trial court, how does it turn around and say, I ruled that it was equitable to stick with the original decision?
The Court of Appeals agreed with you and said the district court made an error of law in characterizing the property as separate property. So once there's that error of law, the district court's got to redo it, right?
Well, I mean, the remand really doesn't say to redo it. The remand says determine whether or not it was equitable.
Right. Follow 23802C.
Right.
And are you asking us to tell the district court to do anything other than follow 23802C?
I believe the Boutro rubric sets out a social policy, a guidance for the court on how to do that. That's in addition and a subset of what we have in the general law. And I think it's helpful. It's not only helpful to the court, but it's helpful to the bar as we try to guide settlement. Instead of having it, well, this is just in the wind. If it's in the wind and there isn't any kind of guidance, we're going to try every one of these things.
isn't Buteau, I don't know how to say it. The Court of Appeals decision in 2000, isn't it inconsistent with our mechanical approach statute 232801? I mean, they specifically say, we're not going to follow that mechanical approach. We're going with this analytical approach, which is not put everything, as Justice Wall said, in a big pot. We have to consider the nature. I mean, to me, it's, that's not on appeal here, but it seems to me that that is completely inconsistent, and you would like to adopt that with the statute.
Again, because you have the statute there as the guidance of what to do. It highlights the analytical approach, highlights this unique nature of a personal injury award that is exactly the kind of story we have here.
But isn't it appropriate to analyze the nature of the award under 232802?
Therefore, it's not, to your first question, inconsistent with the statute.
Well, it seems like Buteau says, no, you got to do that from the beginning, not in the 2802. That you got to say at the outset, okay, we're going to separate it. We're not going to have a big pot, as Justice Wall said. We're not going to have a big pot. We're going to start at the beginning by considering the nature, and then we'll go and do, but everybody gets their own stuff, like in my inheritance. Oh, okay, well, that, the father-in-law hated the son-in-law, and so didn't want a penny of that $2 million to go. So we're going to separate that out at the beginning before we talk about under 2802, what is equitable. That's kind of how I saw it.
I see it as being part of the marital estate, therefore under 02, and guiding further, looking at those structures of how to protect the injured party.
But that's what the Court of Appeals did here
Mhm.
in remanding it. So I would just point to Justice Caleb and say, what's wrong with that then, if that's what you're advocating for?
Again, I think the Buteau case voiced a very important social policy to a unique asset of the marriage. These assets, they either come in as a whole, such as a judgment after a jury trial or trial, but they're intended to be satisfying needs that reach past the marriage.
So wouldn't a better place to object to this be the legislature and have them create an exception in a law or have a subsection that talks about that? Why, it is clear from this statute, and this is what we do. We don't make policy. So even though you've talked about, well, the policy of the district court, courts don't make policy, okay? We follow the law as the legislature passed the statute. So, are you coming to the wrong place to challenge this? Wrong branch of government?
I suppose we fall into the circular argument of it's been there for a quarter century as the law of the land, and the legislature didn't in any way.
Well, I don't know that it's the law of the land. You're saying that it's as a general rule in your 30 years of practice, this is how the courts have done it. But, I'll bet we can find cases, not even cases, but if we rifled through all the hundreds of thousands of, documents at the district court level, I'm sure there's some judges that don't do that.
Oh, I'm sure.
Right.
Can't you argue on remand that the judge is not bound by res judicata? We don't have the same parties involved, for one thing. And that equitably, they have the power to divide those annuities differently, and that they should divide them differently. Don't you have the power? Don't you have the ability to do that on remand as the Court of Appeals left it?
Yes, and I believe that happened in the trial itself. That was the core of the argument. And, you can't make the Buteau type argument without making that argument. So I get your point in the sense that the Venn diagram is virtually on top of each other.
Other questions? Okay. Thank you. Mr. Sternberg.
Thank you, Honor. May it please the court. Again, I'm Jonathan Sternberg and I represent the appellee Nancy Meek. Your Honors, I spent a lot of time preparing for this, and I was going to start off by a discussion of issue preservation, which the court did grant our conditional cross petition. But because of that discussion that the court just had with my opposing counsel, I'm going to scratch that entirely. I still think the court should weigh that. But I'd like to address some of these issues. Let's step back and start from the district court's perspective. At the time in the district court, it's a trial court. The Court of Appeals, anything the Court of Appeals decides is binding authority on Judge J.R.M. in Johnson County. Judge J.R.M., as the special master saw, as the parties I don't think disputed at the time, was faced with a series of decisions, starting with Lash and Butow, I'm not sure how to say that either, from the Court of Appeals, which all do say very specifically that personal injury awards don't necessarily have to be marital property. Well, what's Judge J.R.M., what's the special master, what are the parties to do with that? We have to follow it, right? We're in the district court. We have to follow what the Court of Appeals says. The Court of Appeals, however, when it got here, Judge Hurst and Judge Atchison and Judge Isherwood looked at this and said, you know what? Those cases are wrong. Unlike Judge J.R.M., they weren't bound by those prior decisions. And you know what? They're entirely right. I'm kind of in the awkward position because I was trying in the Court of Appeals to defend the district court's judgment. But then when we got the Court of Appeals judgment, I agree it's right. Now, Judge Stegall, you asked, why are you here to the other side? Frankly, I was the one who could have filed a petition for review on this. It was our position that this was separate property that the Court of Appeals was rejecting. The Court of Appeals, though, I think clearly got this right. This is a statutory question in Kansas. The cases that the Court of Appeals was basing that the prior decisions were basing this not go in the bucket. I think that's a great way to put it, that it's separate property. That's what they specifically said. And that's what Judge J.R.M. says. He says, based on those decisions, the annuities are, quote, separate property that don't even go in the bucket in the first place. The problem with those decisions is they're not based on Kansas law at all. They cite cases from Colorado and Nebraska and Missouri and Illinois and other states. I also practice in Missouri and Illinois. I'm very familiar from doing family law appeals in those states, how it works. There, it's not a jurisdictional issue, it's an authority issue, but you look at a piece of property and first determine whether under the statutes and common law, it qualifies as separate or marital property. If it's separate, it gets set aside to the other side or to the parties. And then what's left is the marital estate that gets equitably divided. Kansas, since 1968, has not done that. Since 1968, Kansas has been what they call, the Court of Appeals quoted this, a total divisibility state. So all of this, from those old Court of Appeals decisions, from what Judge J.R.M. decided, are wrong. Instead here, the parties' personal injury awards, the future annuities, and it's really just the future annuities that were at issue here, not the underlying cash lump sum awards, which have already been distributed to the parties. That all goes in the bucket and then gets equitably distributed. Why they're here, Justice Stegall, to answer your question, I like Mr. Booth. I don't know what's in his mind, but what I think the issue is what they want is some kind of overarching direction to district courts that whenever you're faced with this kind of an annuity, it must go, that annuity must be divided itself between the parties as part of the equitable distribution. What the Court of Appeals held here that they disagree with is, I think, it's not in, they didn't file a brief, is that they said, look, we're going to remand this back so that Judge J.R.M. can take a look at this again under 232802C, apply the 10 factors. But they said as an aside, he doesn't necessarily have to change the outcome. Now, of course, that's a correct decision. I think what Mr. Booth means by saying we want, the court to apply the public policy of Butow is to effectively direct district courts that whenever they're faced with this kind of situation, they must do what he wants.
Can I just interrupt?
Yes, Your Honor.
So I asked opposing counsel about the impact of the Court of Appeals decision. I want to ask you the same question.
Yes, Your Honor.
Where I started from was, it looks to me like the Court of Appeals just said, essentially what you've summarized, the decision was wrong as a matter of law, as was all of our precedent. You have to consider it as marital property. And then you go do what's commanded in 23-802C, which is the 10 factors. And do you agree that that's what the Court of Appeals told the district court to do?
I agree 100%.
And you don't disagree with that? In other words, you're not contesting that?
I'm not contesting that. When we got the decision from the Court of Appeals, after the oral argument there, I frankly wasn't terribly surprised that this was the result, because both of us were surprised by the tenor that the panel was taking there. But I had a discussion with my client and the trial counsel about should we attempt to challenge this in the Supreme Court? And we realized that this was right, and this was a fight we should have as a matter of equity back in the district court. Because frankly, if you look at Judge J. decision, pages 108 to 109 of volume 1, this is, I don't think he actually put page numbers on his decision itself. He uses terms like fair, just, equitable. He felt that this was a fair and equitable result. Now, my opposing counsel just said that, well, in his 30 years of practice in Kansas, take inheritances, Justice Standridge, you mentioned that as an example, that, usually it goes to the party who inherited, who received the inheritance. I had a case just 2 years ago in the Court of Appeals where the husband, I represented the wife, the husband had inherited $10 million from his parents. He was contesting on appeal whether the wife should have received, I think, a total of like $6 million of that. It was a disproportionate amount, in fact, and the Court of Appeals affirmed. I don't think it was Judge J. but another Johnson County District Court judge's decision that that's how it should be. It's a question of equity, and those 10 factors go to fairness. It goes to the circumstances of the parties. Now, one thing that
Can I just interrupt right
Sure.
there? So do you agree then that on remand, under those 10 factors, specifically number 5,
Mhm.
the district court can fairly and equitably consider that personal injury award, what it was for, who incurred the loss, how large the relative loss is, under number 5, which says the time, source, and manner of acquisition of property?
Certainly, it can consider that. Now, there's a couple of things you had a discussion, Justice Wilson, with my opposing counsel about the quality and what this award was about. And there were a couple of inconsistencies, I think, with the record in that discussion. One was that there was no demarcation in the agreement of who was getting what. That's simply not true. In the settlement agreement, which is volume 13, pages 18 to 20 of the record, it clearly lays out that my client that each party would receive a specific lump sum for his injury and then for her loss of consortium. And then there would be a specific annuity schedule, which are not in equal amounts. They are in different amounts. In fact, my client's is slightly less than the appellants of how that annuity would work in total. So
The court isn't bound by that, is it? Because the award was granted at a certain time, and the divorce is granted later. So for Judge J. or any district judge to say, well, I'm bound by that, by principles of res judicata.
So
There's all sorts of reasons why that's wrong, correct?
I appreciate that he used the words res judicata. I don't think he was saying that res judicata prevents me from considering the purpose of this. I think he considered the purpose of it in great detail. What he's saying is that certain testimony of the appellant that he found not credible was that he was coerced into the agreement and he was misled or fraudulently induced into executing it. Judge J. said, I find that not credible, and then says it's also in contravention of basic legal principles of res judicata and fundamental interests of finality, justice, and certainty. He's not saying that that I can't consider the purpose. But I think
Well, finality seems to indicate that he does feel like he's constrained by that in some way. And in fact, under this statute, he's really not.
And I appreciate if that was what he was thinking in writing that, then I agree with you that he's not actually constrained by that. But he can still take it into account. And here, even under the analytic approach cases, I think if there is any public policy that comes from it, it's that when you have an award that's a future award, so here we aren't just talking about some lump sums. The parties already received their lump sums. No one is even fighting over that. The only thing that's being fought over here are the annuities themselves that the parties are now receiving for years and decades to come. In all those prior cases, I think what's interesting about them is they said, so let's take this out of whether it goes in the bucket or not. Let's take it back into who gets it, right? It is marital property. It's got to be divided to somebody. So in the Powell case, the cash funds that the party had received were equitably divided between the parties as marital property, in fact, equal. But there was also a separate future annuity to the husband for his personal injury that was assigned to him separately. And nobody challenged that. Now, while they were talking about separate property, I think the same equitable, considerations come in for for who gets it, for who it gets
It
divided.
was separate assignment within the bucket.
Exactly, precisely,
Well,
which of course the court can do. That's the purpose of 2802.
And just to clarify,
Yes,
the issue of who gets the property is not in front of us. Correct?
correct, because that's what the Court of Appeals remanded to Judge Jairam, and no one has sought review. I agree. But the same thing, the Lash case, the property award was skewed toward the wife because a cash award was to be used for future losses. In Butow, which we keep fighting about, there was a lump sum that was determined to be a marital asset, but the husband's annuity was once again given to him as his separate property. So that can be done. Judge Jairam can do that still using the same equitable considerations. And part of this is, the other side doesn't view the facts in the light most favorable to Judge Jairam's decision at all. There is partly a factual consideration in this. When determining who gets what out of that big bucket, who gets these annuities, if a consideration is, and I think it can be under subsection 5, that it's to compensate wife for a future loss. My client testified in pretty great detail at the trial, pages 53 to 54, especially 63, that she continues to suffer the loss of consortium. In fact, the loss of consortium was in large part a reason that precipitated the divorce itself. And that the purpose of this annuity was to ensure that in the future, despite her husband's and now to be ex-husband's disability, the party's children, who she cares for primarily, would have a parent that is there to ensure their safety and well-being and ensure their financial.
But doesn't loss of consortium stop on the divorce?
So
She can no longer, in the settlement, they presumed they would remain married and the loss of consortium would continue until the end of their lives. But with the divorce, the consortium stops for the woman. She was the only one that got that loss. So actually, the prediction at the time of the settlement is going to end up to be different from what the judge considers at the time of the divorce, correct?
I appreciate it could be looked at that, but again, I don't think the judge has to see it that way. So the consortium itself, obviously, if they weren't married and a man, let's say they're a boyfriend and girlfriend, and the boyfriend has a terrible personal injury, there isn't a loss of consortium to the girlfriend because there's no marriage. But at the time of this injury, there was a loss of consortium. While my client couldn't bring that claim today, the loss she experienced back then had implications for the future, which is the reason for the future annuity. No different than the fact that his injury occurred at a specific place in time, but the effects of that injury continue into the future, which is why he gets a future annuity as well.
And they may be more or less.
Exactly. That's correct.
The thing I've been struggling with this thing is the reality of the deal is that when you're in the settlement conference and there's a pot of money here to allocate, the first consideration is how do we divide it up so that we avoid taxes? And then, and I've seen all kinds of manipulation of how you might logically divide things up because of the taxes or how the annuities are going to work, which to me speaks strongly in favor of the way the Court of Appeals analyzed this, because it can go back and the court can not presume that the parties had real reasons for putting more money in consortium than loss of wages, which would be the more taxable kind of event. The court can weigh all that is all we're getting at. And that's why I think the Court of Appeals decision had some pull for me, some persuasion to me.
I don't disagree. And I think as Justice Deagle asked me, is that even before us? I think the back and forth you and I have had, Justice Wilson, and I think, no, it really isn't. This court's not going to give direction on Judge Jairam, how he's going to, exercise equity. Although one thing I'll mention, which my opponent mentioned, is that they were treating these as income to calculate maintenance and child support, these future annuities. And if they're treating them as the party's separate income for that, I think that's another part of the equitable consideration of who gets what. We're going to say that if we're going to calculate my client's requirement to pay her ex-husband maintenance based on her getting this income, and now he's going to get part of the income, I think the judge can find that inequitable too. Seeing that I'm out of time, if there are no further questions, we ask the court to affirm the Court of Appeals judgment.
Thank
So
you, Mr.
let me clear, you're asking to affirm the Court of Appeals judgment, correct?
Well, ideally, I'd like you to reverse the Court of Appeals and order his appeal dismissed, because I don't think any of this is preserved for appeal in the first place. He never made
Understand,
any of
but
these
that's
arguments.
what you're at.
But otherwise, yes, affirm the
I think
Court of
Mr.
Appeals.
Booth is asking for the same relief.
I'm confused by it too. Thank you, Justice Rosen.
You reserve 3 minutes, Mr. Booth?
Well, let's start off, Mr. Booth. Are you asking for the same relief as counsel? You're asking us to affirm the Court of Appeals. Is that right?
No, in the sense of tossing out the Butro directions for the court. I think that that the idea that Butro sets out a rubric or a methodology in which you look at this unique species of personal injury awards. They're in the hodgepodge. You're supposed to.
Would you have us make that compulsory? I just, with the statute, how do you, I just don't know what you want us to do with that case law, given the discretion that exists in the plain language of the statute for equitable division. It seems to me like the district court judge certainly can take follow that approach or not. And that's what the legislature has laid out for the district courts.
I think a concern is that the Court of Appeals decision could be taken as don't consider those factors and consider it as any other species of.
Why wouldn't the Court of Appeals decision and ultimately our court's decision, if we affirm it, be taken very clearly to be follow the statute? And why is that inadequate from your perspective? And by the statute, I'm talking about the 10 factors in 2802.
There's very little in 2802 that directly shines a light on the unique species.
So we as a court need to supplement 2802. That's what you're asking us to do. I just want to be clear with what you're asking for.
I think that's a fair statement, as is every decision that either the Court of Appeals or the Supreme Court makes when it comments on the effect of a statute. Of the things that I wanted to, one of the last comments of opposing counsel was that they included in the income, the personal injury award. Well, they did include the monthly payments as a construction of what the child support and maintenance would be. But you can't not include those monthly payments and presume that the court's going to rule differently when you look at the definition in child support of what income is. It's anything occurring on a regular from whatever source. And we usually go by the child support number when we figure the maintenance number. They can obviously divert for all kinds of reasons, including other reasons for maintenance. And the court mentioned that it didn't like the maintenance award, but it was going to stick with what the parties had proposed in the pretrial. It did not consider the lump sum awards that come every 5 years, I believe it is. I know one's coming in 2025. And those are sizable and went past the period of maintenance. The period of maintenance was only 3 years. So one does not rely on the other. And the lower court sort of saw that as duplicitous or contradictory when the lower court said, you asked for this maintenance based upon this standard, but now you're asking for some of the money that you're getting maintenance from. Well, the court wasn't bound by the proposal of what the maintenance was going to be. So the court could have done something very different in property distribution that would have affected that income stream, and it would have dramatically changed what the child support would be, and what the maintenance would be. So there was nothing that bound the court to the parties' joint suggestion on what the maintenance would be. If the court wanted to be bound, it would have had to have been a stipulation of fact or an agreement by the parties that the court determined whether or not it was fair, just, and equitable. The outcome of the trial court's decision has to change. If you look at the reasoning behind the change was bound by the original agreement. I'm not going to consider any other factors. And we'll go back to the conversation here. Whether or not you uphold the Court of Appeals, if you uphold the Court of Appeals in a one-line statement, we're just fine with that. The outcome has to change because the district court's decision ignored any purpose behind that award. And just said the reason why it's fair is because they made the agreement some years ago. And if they thought it was fair, I got to think it's fair too. And I'm bound by the res judicata effect. And that's all I have.
Questions? Thank you.
Thank you.
Thank you to both counsel for your arguments. We will take this matter under advisement. The court will be in recess until 11:05.